Good morning,
But
my
Mr.
lord.
Kelly is, yes,
Yes, my lord.
it's like I've seen somebody, Joy.
Yes, good morning, my lord.
Hey, Joy, good morning. How are you?
I'm fine, my lord. Sorry for
Yes,
the
even though-
network.
yes, Joy.
Joy Umesofo.
Okay,
Appearing
yes, so for
for the defendant.
okay. Thank you. This is my judgment. The claimant commend this action by way of complaint and other accompanying processes filed on the 10th of June 2019 and asked for the following reliefs as contained in the statement of fact against the defendant. Number one, a declaration that the defendant refusal to promote the claimant from the employment grade level of manager to the grade level of senior manager in 12 months upon achieving 6-month key performance indicators as contained in the letter of the offer of employment, which was achieved by the claimant as of December 2014, was wrongful and amount to a breach of the contract of employment. Number two, a declaration that the claimant is entitled to compensation from the defendant for a period of 22 months for which the claimant used his personal vehicle for the defendant employment services due to the failure of the defendant to provide the claimant status car or payment in lieu. Number three, a declaration that the defendant's refusal to issue the claimant with a month notice before termination of the claimant's employment or payment in lieu of notice in accordance with the terms of the employment was wrongful and amount to a breach of the contract of employment. Number four, a declaration that the claimant is entitled to the payment of the sum of 907,000 naira salary for the months of December 2018 from the defendant being payment in lieu of a month notice. Number five, a declaration that the defendant's termination of the claimant's employment on ground of poor performance is misleading and incorrect, and same makes the termination to be wrongful. Number six, a declaration that the claimant is entitled to compensation from the defendant for wrongful termination of the claimant's employment and the loss of employment for no fault of the claimant and for dashing the claimant's hope and job prospect. Number six, an order for the defendant's payment of the sum of 5 million naira only as compensation to the claimant for the loss of earning of salary equivalent to that of a senior manager. So the defendant failure to promote the claimant to the grade level of a senior manager in accordance with the terms of the employment letter. Number seven, an order for the defendant payment of the sum of 2 million naira only as compensation to the claimant for the wear and tear that affected the claimant's personal vehicle that was used by the claimant in furtherance of the defendant's services for the period of 22 months due to the defendant's failure to provide the claimant with status car in accordance with the terms of the employment. Number nine, an order for the defendant payment of the sum of 907,000 naira in lieu of a month notice. Number 10, an order for the defendant payment of the sum of 30 million naira being claimant's annual salary for 2 years as compensation damages to the claimant for the wrongful termination of the claimant's employment and the loss of employment. Number 11, an order of general damages in the sum of 5 million naira for breach of contract of employment. Number 12, an order for the sum of 1 million naira as the cost of litigation of this suit. Number 13, post-judgment interest of 5% on the judgment sum from the date of judgment until the final liquidation of the judgment sum. The defendant, in reaction to the claimants, should enter appearance and file a statement of defense and counterclaim on the 18th of November 2019 via leave of court. Meanwhile, the claimant also filed a reply/defense to the defendant's statement of defense and counterclaim on the 10th of March 2020. Case of the claimant. From the pleadings filed by the claimant and his testimony, he joined the service of the defendant on the 2nd day of June 2014 on the grade level of the manager in the Lagos and West Division based on his previous experience from other banks by virtue of letter of employment dated 24th April 2014. That his employment letter contained a promotion clause for him to be promoted from the grade level of a manager to a senior manager in 12 months upon achieving 6 months performance key indicators. 6 months key performance indicators as contained in the employment letter. That the claimant achieved the 6-month key performance indicators as contained in the employment letter and was adjudged to have achieved 1.7 billion deposit in the branch in 6 months and was graded to have scored 81.67%, but was never promoted to the grade level of senior manager before the wrongful termination of his employment on the 21st of November 2018 on the ground of alleged poor performance. Claimant also stated that his termination of employment was immediate as he was neither given 1 month notice nor paid salary in lieu of notice for the said period contrary to the terms of the employment. It was further stated that the claimant upon his employment was entitled to a status car from the defendant as part of the terms of his employment, but he was never provided with the status car until after a period of 22 months of presuming with the defendant. According to the claimant, for the said period, he was using his personal car to carry out the defendant's services without any compensation or payment in lieu of the provision of status car, thus entitled the claimant to compensation for the wear and tear that affected his personal vehicle. Case of the defendant. In the case of the defendant, on the other hand, that the claimant was its employee until when his employment was terminated on the 21st of November 2018, and that the promotion of the claimant to the position of a senior manager was subject to a condition precedent as stated in his letter of employment, which condition was not made by the claimant. On the allegation of non-provision of status car, it is the condition of the defendant that a status car is provided for qualified employees in batches and subject to management's approval. But in the absence of status car, the claimant was provided a pool car which conveyed him from work to home and back to work, and at the same time, he was paid drivers and auto maintenance allowances before the status car was handed over to him. The defendant also contended that the claimant performed poorly, hence his termination after several. Meanwhile, the defendant in his counterclaim claims defendant/counterclaimant claims against the claimant/defendant counterclaim the sum of 1,593,884 naira, 3 kobo, being the outstanding indebtedness of the claimant/defendant to the counterclaim for the net book value of the status car retained by the claimant/defendant to the counterclaim. On court. Trial. Claimant gave evidence as CW1 in support of his pleadings on 14 July 2021, where he adopted his witness statement on oath dated 10th June 2019 and 10th March 2020 respectively, and tendered exhibit GM1 to GM25. Claimant was cross-examined by the defense and his case was then closed as there was no re-examination. The defendant opened his case by calling his sole witness Julius Oedeji, who adopted his witness statement on oath dated 18th November 2019 and tendered exhibit KB1 to KB12. Defendant's witness was then cross-examined by learned counsel to the claimant and discharged. The case of the defendant was then closed and the matter was adjourned for adoption of final written address. Defendant's final written address. Defendant's final written address dated 16th September 2022, but filed on the 22nd September 2022 contains 4 issues for the court determination. Number 1, whether the claimant was deprived of promotion to a position of senior manager. Number 2, whether the claimant's employment was wrongfully terminated. Number 3, whether the claimant has made out a case for himself entitling him to the relief sought. Number 4, whether the defendant/counterclaimant successfully proved its case. On issue 1, counsel to the defendant submitted that the claimant was not deprived of promotion to the position of a senior manager, and that promotion is the prerogative of an employer following a critical appraisal of the employee's performance and contribution to the company's growth. Hence, the inclusion of the condition precedent in the claimant's letter of employment. He cited the case of Onwe and Fan, where the Supreme Court held that promotion from one level of position in an organization to another is not a right but a privilege, which is earned. That the position of a manager to a senior manager is subject to conditions provided in Exhibit KB 3A to F, and upon fulfillment of the conditions contained therein. Defendant referred to Exhibit KB 4, 5, and 6, which are warning letters showing that the claimant's performance was below par. On issue 2, counsel to the defendant posted that the termination is a party's contractual right to bring the employment relationship to an end after giving the required notice or payment in lieu of notice. He referred to the case of Union Bank and Salahuddin. Learned counsel posited further that the defendant did not breach the mode of termination as agreed between the parties, and as such, the claimant employment was validly terminated. That the defendant opted for option 2 in the severance clause as provided for in Exhibit 3, and the quantum as provided for in Exhibit 9, which is the payment of 1 month basic salary in lieu of notice to the claimant. And the defendant did comply with this as seen in Exhibit 10. Page 7 of Exhibit 10 shows that on 21st day of November 2018, the claimant's account was credited with a sum of 271,000 naira under the narration payment of 1 month in lieu. On issue 3, counsel stated that it is only when a claimant makes out a case that the burden of proof now shifts to the defendant to adduce counter evidence in opposition to the claimant's evidence and sustain its defense. While the claimant first make out a case, then there's nothing for the defendant to rebut, and the case is liable to be dismissed. So the case of Okomu Oil Palm Company Limited and Isehen. The termination of the claimant's employment was on account of his poor performance, as overwhelmingly evidenced by Exhibit KB 7A to G. It is counsel's submission that where a claimant seeks declaratory relief, as in this case, the evidence in support of same must be overwhelming, total, convincing, and most importantly, credible. The claimant must succeed on the strength of his case and not on the weakness of defense, as held in the case of Zikantoro and Antoro. It is defendant's further contention that in a claim for declaratory relief, the claimant must place sufficient materials before the court to enable it to exercise its discretion in its favor. And to this end, it is counsel's submission that the claimant has not been able to establish facts and lead credible evidence entitling him to the grant of the relief sought. On the 4th issue, learned counsel argued that Exhibit 9, particularly at page 80 under heading Retention of Asset, provides for what happens to the defendant asset in the possession of or custody of an employee whose relationship with the defendant has come to an end. The relevant provision provides that 10% of cost or the NBN, that is net book value, whichever is higher, of the asset is to be paid by the employee who is in possession of the asset and who intends to retain them. That just as the claimant in the instant case, the provision also provides that where the existing staff cannot immediately pay for the asset, the sales price of the asset as stated above shall be computed and added to the net indebtedness of the staff or deducted from his or her final entitlement as applicable. And that the claimant, despite being in the receipt of the defendant's email, failed, neglected to respond to the email despite the options given to him in the email. Counsel finally stated that the argument on the depreciation of the car is misconceived, as the depreciation of the vehicle cannot take a retrospective date, and the depreciation will commence at the date the vehicle was handed over to the claimant. Claimant's final written address. Claimant final written address dated and filed on the 18th of October 2022 contains the following issues for determination as submitted by counsel to. Number one, where the claimant achieved the 6-month key performance indicators for promotion as provided for in the promotion clause contained in the employment letter, and whether the defendant breached the said clause by failing to promote the claimant and thus entitle the claimant to compensation damages for the breach. Number two, whether the claimant was entitled to a status car from the defendant under the terms of the contract of employment, and in 2 months from the date of commencement of the employment entitles the claimant to compensation for the wear and tear occasion his personal vehicle that he was using for the defendant's work. Number three, whether the defendant failed to pay the claimant his full 1 month salary in the sum of 927,000 naira in lieu of notice of termination, as provided for in clause 6 of the employment letter, and thus entitled the claimant to the balance of the sum of 555,000 naira. Number four, whether the defendant has failed to prove his reason for termination of the claimant's employment, which is poor performance, as stated in Exhibit GM7, and thus entitled the claimant to damages for wrongful termination of employment. Number five, whether the defendant has either pleaded any material facts or adduced evidence to prove the claim of 2,300,000 naira as NBV of status vehicle as at 21st November 2018, or the counterclaim for the sum of 1,593,000 naira at the balance of the NBV. On issue one, counsel referred the court to paragraphs 10 to 28 of the Statement of Fact and Exhibit GM1 and GM4 to state that there is a promotion clause in the claimant's employment letter, which was the incentive that induced him into taking the offer since he had already attained the grade level of senior manager in his previous employment with the last bank that he worked with before joining the defendant. Counsel also referred to Exhibit GM16, Wema Bank PLC letter of promotion of the claimant to a senior manager dated 12 November 2007. The counsel also stated that the claimant satisfied the 6-month key performance indicators as he was adjudged to have achieved 1.7 billion deposit in his branch in 6 months, made a profit of 50 million within the said period of 6 months for his branch despite meeting bad loans in the branch books, and was graded at 81.67%. That despite the claimant satisfying the stated condition, the defendant refused to promote him and thus breached the promotion clause. It was argued that had the claimant been promoted, he would have been entitled to a monthly salary of 1.1 million naira as a senior manager from June 2015 to the date of termination of his employment, as against the sum of 927,000 naira paid to the claimant as a manager, an earning difference of 200,000 naira. Counsel submitted that Exhibit GM4 defeats the defendant's defense, and counsel urged the court to discountenance him that the claimant satisfied the condition for promotion, but was denied promotion by the defendant, which amounts to a breach of the promotion clause, which is a fundamental term in the employment contract, having been incorporated in the employment letter. That the fact that the employment letter contains a promotion clause takes the issue of promotion from being a mere privilege to a right which is enforceable under the contract. Thus, the decision of the appellate court as cited by the defendant that promotion is not a right but a privilege is not applicable to the instance case. Till submission of counsel that the fact of this case and that of the cases referred to by the defendant are different. In those cases, there was no promotion clause in the letter of employment, and that distinguishes the fact of this case from the cited cases. Counsel reaffirmed the position of the Supreme Court in South Atlantic Petroleum Limited, and Minister of Petroleum Resources, that it is the fact and circumstances of each case that determine judicial authorities, that counsel ought to cite in support of their argument in court. Counsel also submitted that in the instance case, it was the intention of the parties to make promotion a fundamental term of the contract, and that is why it was included in the employment letter. The defendant cannot be allowed in law to renege on the promotion clause by arguing that promotion is a privilege and not a right, having represented to the claimant in the letter of employment that it is a right and not a privilege. The law is that a party who has admitted the existence of a fact is stopped from denying the existence of that fact, citing Section 169 of the Evidence Act, citing also the Supreme Court decision in the case of Oyeyemi and Commissioner for Local Governments, Kwara State. It is the first submission of learned counsel that the law is settled that when there is a breach of the term of contract, the injured party is entitled to damages as compensation for the injuries suffered as a result of that breach. In this case, the claimant has lost a salary earning difference of 200,000 naira from June 2015, when he ought to have been promoted from manager to senior manager, to the date of termination of his employment. The counsel submitted on issue 2 that the claimant is entitled to a status car from the defendant by virtue of his contract of employment, which the defendant did not provide until after 22 months of using his personal car for the services of the defendant. But all that the defendant provided for his 22-month period was drivers and auto maintenance allowances, which obviously affected the wear and tear of his personal car, hence is entitled to compensation. Counsel submitted on issue 3 that the monthly salary in the sum of 927,000 naira in lieu of notice of termination as provided for in clause 6 of the employment letter was not fully paid to the claimant, and he is thus entitled to the balance of 555,000 naira. That the claimant's employment was terminated with immediate effect, but his letter of employment provides that either party shall determine this contract by giving 1 month or payment for the same period in lieu of notice. However, what was given to the claimant was 1 month basic salary as is erroneously contained in Exhibit KB9/GM25. On issue 4, counsel submitted that the termination of the claimant's employment on ground of poor performance was wrongful because, according to the claimant, his performance as a branch manager of the defendants, Apapa Point Road branch for the year 2018 was outstanding, as his branch achieved a profit of 222 million naira and became one of the top 5 most profitable branches of the defendant. Counsel also submitted that the defendant in his defense did not deny the substance of the claimant's pleadings of the said achievement, performance, and income generated by the branch in 2018, and this is taken as admission. The only defense put forward defendant is that the table and figures reproduced by the claimant refer to branch performance score rather than the claimant's individual score sheet, which form the basis of staff appraisals. This is an admission that the fact as pleaded by the claimant represents the achievement of the branch managed by the claimant, referring to paragraphs 29, 30, 31, 34, 35, 36 of the statement of defense. According to the claimant, the termination of the claimant's employment by the defendant on the ground of poor performance was done recklessly without following the established standard of appraisal rating as stated by the defendant is said. That it is clear without doubt that there was no appraisal rating for the claimant's performance for the year 2018 in line with paragraphs 61 to 63 of Exhibit KB9 before the termination of the claimant's employment on the ground of poor performance. It was argued by counsel that Exhibits KB7 and KB8 be relied upon by the defendant as evidence of poor performance and as the basis for the termination of no moment or material value, since they are not in moment or material value, since they are not in line with the procedure as contained at pages 61 to 63 of Exhibit 9. That Exhibit KB7 warning letters relate to the branch performance appraisal except one dated 15th May 2018, which relates to the claimant's personal performance appraisal. It was also argued that the claimant who the defendant adjudged to have performed poorly in the year 2018 was appointed a coach in the month of October 2018 by the defendant to supervise and enhance the performance of one of the defendant's underperforming branch managers, Mr. Adekule Ajay-O. The claimant was given a PIMS coaching program manual by the defendant pursuant to the appointment of a coach, which appointment was contained in an email/system generated message dated 17 October 2018. The defendant policy Exhibit 9 at paragraph 4.0, pages 65 and 67 provides for performance coaching as one of the bank's performance improvement interventions for underperforming staff within various strategic business units in the bank. The coaching program runs for 3 months, within which underperforming staff will be assigned a coach whose responsibility will be to help improve performance and identify weak areas and move the underperforming staff to an acceptable performance level. That if the defendant is true as to the fact that the claimant's performance was poor, the claimant was entitled to the benefit of a coach under the defendant's coaching policy to help improve his performance before his employment can be determined on ground of poor performance. The defendants also fell in this area because the DW1 admitted under cross-examination that no coach was appointed for the claimant to assist the claimant improve his performance, even when he was entitled to one under the defendant's policy. The implication of this evidence is that determination on the ground of poor performance was even premature in the first place for not affording the claimant opportunity of performance improvement under the defendant's coaching policy as provided for in Exhibit 9 at paragraph 4.0, pages 65 to 67. The submission of counsel that this issue of termination on ground of non-performance was considered by this court in a judgment in a sister case, Joshua Ayenderan and Keystone Bank Limited, delivered on the 16th day of December 2021 by Honorable Justice Ogumbowale. Counsel also referred to the case of Olatumbosun and NISCR Council to further argue that even though an employer is not bound to give any reasons for terminating the employment of his employee, but where the employer gives reasons, the onus then lies on him to establish that cause or reason as trial to suspension of the court. that while the employer fails to justify that reason, when contested by the employee, it will amount to wrongful termination of employment of which damages will apply, because it will be construed as wrongful dismissal without more. Such in the case of Alabidun and president of the FIM. On the issue of compensation for wrongful termination, Council refers to the case of Akin Setia and Westakego Nigeria Limited and following Oreke and incorporated trusts of Clinton Health Access Initiative. On issue 5, Council contended that the position of the law on special damages is fully settled. Such in the case of Ene and Uzo. The Council also contended that the defendant has based its counterclaim on Exhibit 9. The said Exhibit 9 provides that where an employee exits the employment of the defendant either by forced exit or voluntary exit, and while the asset has not fully depreciated, the said employee should retain the asset for 10% of cost or NBV, whichever is greater. It's also the contention of a council that one would have expected the defendant counterclaiming to provide particulars in support of the counterclaim as how it arrived at its calculation of 2 million naira, which is the foundation and basis for the claim of the balance of 1.5 million naira. So the first submission contention of council that one cannot determine 10% of cost or the NBV as provided for in Exhibit 9 without first determining the purchase price of the vehicle and the depreciation value of the vehicle as set out as said by the defendant in his policy. That these are particulars that ought to have been pleaded by the defendant, which it has failed to do. Contending further, counsel stated that the defendant's counterclaim for the sum of 1.5 million naira at the balance of the NBV of status vehicle must fail, and the defendant failed to adduce any pleadings or evidence, whether oral or documentary, on how it arrived at the aforementioned sum of 2 million naira. Counsel referred the court to the judgment in a sister case of Olayinka and Keystone Bank Limited, delivered on 29th of June 2021 by Honorable Justice Ogumbowale, where the court held that the defendant has not proved to the court how it arrived at the sum being claimed as counterclaim, the mode of calculating the depreciation NBV of the status car. On the issue of cost, counsel finally contended that the claimant is entitled to litigation costs for prosecuting his suit if he wins, and for defending the counter suit if the defendant counterclaim is. That's in the case of Master Holding Nigeria Limited. Haja, please mute yourself. Haja. Sorry, Haja. Please mute yourself, please.
Okay, sir.
Mute yourself, please.
Yes, sir. So sorry, sir. I thought I...
No. So this is my opinion. I've studied the pleadings of the parties and the evidence adduced. I've also carefully read the submission of the Landed Council for the parties, which contains several issues for determination. But I will consider 2 issues for determination, which I think will take care of the issues submitted by the parties. The issues are, number 1, whether the claimant has proved his case to be entitled to the reliefs sought. Number 2, whether the defendant/counterclaimant has proved his case to be entitled to his counterclaim. It is the grievance of the claimant, as earlier stated among others, that the defendant refused to promote him from the position of a manager to a senior manager, and that the defendant failed to provide him with a status car for a period of 22 months. Claimant is also aggrieved that the termination of his employment by the defendant on poor performance is incorrect and wrongful. But for the defendant, promotion is a privilege and not a right, and that the claimant was provided with a pool car and paid drivers and auto maintenance allowances. The defendant also said that the claimant performed poorly, hence his termination after several warnings. On the issue of promotion, it's not out of place to refer to Exhibit GM1 and GM25 or KB9, which are the claimant's employment letter and the defendant human capital policies and procedures manual, respectively. Paragraph 1 of Exhibit GM1 says as follows, and I quote, "Management is pleased to offer you employment with Keystone Bank Limited on the grade level of manager in our Lagos and West Division. You will be upgraded to senior manager in 12 months upon achieving your 6-month key performance indicators as contained in this offer letter. Similarly, the 6-month key performance indicators as contained at the end of Exhibit GM1 are as follows. Average deposit, 2 billion naira. Risk asset, 500 million naira. PBT, 50 million naira, unquote. Claimant has, based on the above, asserted that he has achieved the above 6-month key performance indicators as contained in Exhibit GM4, where he scored 81.67%, and that some deposits and profits were made within the said 6-month period. However, it is my observation that Exhibit GM4 only talks about staff confirmation system, which is measured by staff personal aspect, qualitative result, quantitative result, and accomplishment record, while the claimant scored a total of 81.67% as a requirement for confirmation. Thus, it's my view that Exhibit GM4 only has to do with confirmation of appointment of the claimant, but not promotion, as the claimant wanted the court to believe. So firstly, to say that express mention of one thing excludes the other. See the case of FRN and Osahon. Even at that, Exhibit GM25 and KB9 have made reference to promotion at pages 64 to 65 and 66 to 67 respectively. At pages 64 to 65 of Exhibit KB9, it is stated as follows, and I quote, promotion. The bank shall seek to first fill vacancies by promoting suitably qualified personnel from among the bank's employees. Promotion exercise shall be carried out once in a year after the year-end appraisal. Promotion shall be based on the following. Number 1, qualifying average performance assessment score, promotion readiness, availability of vacancy, time on current grade, absence of disciplinary sanctions. HCMD shall have the responsibility of ranking all staff in terms of their eligibility/priority for promotion. This ranking shall be based on the performance appraisal scores as well as all other factors outlined earlier and form a basis on which promotion decision shall be made. HCMD shall be required to determine the cost implications of promotions and ensure that promotions are agreed within the bank's manpower budget, unquote. Going by the provision of Exhibit GM25 and KB9 on promotion, it seems that some contingencies have to be factored in before a staff is promoted. This is undoubtedly in line with the decision of the Supreme Court in Onwe and Fan that promotion from one level or position in an organization to another is as in the instance case, seems not to be a right, but a privilege. For what it is, Exhibit KB4 dated 11th November 2014 is performance warning letter issued to the claimant saying as follows, and I quote, performance warning. Management has noted with dissatisfaction your continuous loss-making trend. Your profitability performance falls short of minimum expectation in the bank. Your September year-to-date PBT performance stands at 42 million naira. You are strongly advised to grow your PBT in line with earlier advised budget. A return to a year-to-date profitability on or before December 31st, 2014. Unquote. Driving from the above, I found that the claimant has not been able to prove that he has satisfied the conditions of promotion under Exhibit 1 and Exhibit GM25 or KB9. And whether promotion is right or privilege in the instance case is a question of satisfying the conditions for promotion which the claimant bears the burden to prove. From Exhibit GM25 or KB9, promotion is not a matter of course or routine. I'm thus unable to be persuaded that the claimant is entitled to the leaves of promotion sought. The claimant was employed on 24 April 2014, and from Exhibit GM1, he should be promoted within 12 months of satisfying certain conditions, but he did not raise the issue until when he was terminated in 2018. I think it is too late in the day for the claimant to ask for promotion at this stage. It is an afterthought. Therefore, claimants relief 1 for the declaration that the defendant refused to promote him fails, and having failed, his relief 7, which is for compensation for loss of earning owing to his non-promotion, is equally bound to fail, and the said reliefs are consequently dismissed. Turning to the issue of status car, claimant contended that he is entitled to a status car by virtue of his contract of employment, but the defendant did not provide him with same until after 22 months of using his personal car for the service of the defendant, which obviously affected the wear and tear of his personal car. Hence, he is entitled to compensation. However, this does not sit well with the defendant. In addressing this, let me refer to page 81 of Exhibit 25, which states as follows, and I quote, retention of assets. Managers and above are entitled to fixed assets, such as status cars and generators. These assets are provided and disbursed to staff by corporate support, after which FinCon and HCMD are advised to further accounting and records. On no account should the assets assigned to any staff be removed or reassigned to another staff/unit or disposed of in any way without the concurrence of corporate support. Unquote. It can be observed from the above that during the employment period of the claimant, there is no mention of a specific time when the status car will be provided to the claimant by the defendant. Surprisingly, the claimant did not present his said personal vehicle or his particulars before the court for his inspection, let alone show the level of wear and tear on the said vehicle that were allegedly used in rendering services for the defendant. Another surprising thing too is that the claimant was paid drivers and auto maintenance allowances by the defendant during the 22-month period when he was not given the status car. It is imperative to refer to the evidence of the claimant under cross-examination. Here what the claimant said, and I quote, in April 2016, I was provided with a status car. Prior to that time, I was given the status car. I was required to make use of any car from the defendant's pool of cars available at my branch for the defendant's official business. Unquote. To me, there's no satisfactory evidence which the claimant necessarily bears the burden to prove that he's entitled to compensation for allegedly using his personal vehicle, which was purportedly affected by wear and tear. I think the claimant cannot eat his cake and have it. He cannot collect drivers and auto maintenance allowances and make use of the defendant's pool of cars and still ask for compensation for wear and tear on his personal vehicle. I think the claimant has to be consistent in the presentation of his case. See the case of Gerardo Alawan. For the above reasons, therefore, I will have no hesitation in refusing the claimant's claim for compensation of 2 million naira for the alleged wear and tear that purportedly affected his personal vehicle, as I could not fathom how the claimant arrived at the said sum of 2 million naira as compensation. Reliefs 2 and 7 and 8 are accordingly refused. The ground of the said reliefs, being special, has to be by credible and convincing evidence, for it is said to be discernible and quantifiable and does not rest on the silly notion which rise to speculation or estimation. See the case of Ahoronye and Ekone. Comment to the issue of the claimant's termination on the ground of alleged non-performance. Claimant has referred to pages 60 to 63 of Exhibit GM25 or KB9, which set out staff performance management system policy and stated that the standard appraisal rating was not followed by the defendant. The defendant, on the other hand, had referred to Exhibit KB7 as various performance warning letters issued to the claimant due to his poor performance before his employment was terminated. Claimant has contended that his termination on poor performance was even premature, as he was not afforded the opportunity of performance improvement under the defendant's coaching policy as provided in Exhibit 9. However, it should be noted that it is stated at page 66 of Exhibit KB9 that, and I quote, at poor performance levels, the bank may take exit decisions without any coaching process. unquote. This means that assignment of a coach to a non-performing staff is not necessary before his employment is terminated. It should also be noted that disciplinary procedure does not apply or does not need to be followed in the case of poor or non-performance. See section 6.6 at page 45 of exhibit KB 9.2. And I quote, ability and efficiency to perform on a job. The disciplinary procedure shall not be used in case of inefficiency. An employee may be inefficient because he or she just does not have the ability to carry out his or her duties. But this does not come under the heading of industrial misconduct. If an employee is inefficient, the person shall be informed of his shortcomings in writing. If such inefficiency continues, the performance department in HCMD should issue a final letter stating that if there is no improvement in the employee's performance within a reasonable period, usually not less than 1 month, but not exceeding 3 months, the bank will have no option other than to reconsider his or her services. Unquote. I need to further state here that the case of Joshua Ayenderan and Keystone Bank, cited by the claimant, seems to be different from the case on hand. The termination in that case was based on allegation of misconduct and non-performance altogether. But the termination in the instance case is only based on non-performance. The cases are therefore not at par. Each case must be considered on its particular or peculiar fact or circumstances, and no one case is identical with the other or another. They may be similar, but never identical. So it is so with the case on hand. A decision is only an authority for what it decides and nothing more. See the case of Skybank and Akimpelu. The defendant justifying the termination of the claimant presented exhibit KB 7A to G, which are various performance warning letters dated 15th May 2018, 28 August 2018, 8 October 2018, 22 August 2018, and 19th November 2018. However, claimant response to this letter is that they all relate to the branch performance appraisal except one, which relates to his personal performance appraisal. To me, this is an admission of the existence of the warning letters, even though according to the claimant, they do not all relate to him. For clarity, part of exhibit KB 7A dated 15th May 2018 says thus, and I quote, this serves to convey executive management's displeasure on your poor performance towards the bank deposit and account opening / reactivation drive operation hardcore 400 for the month of April 2018. Below is an analysis of your performance. Consequently, this letter serves as a performance warning, and by this, you are strongly advised to improve your performance and overall commitment towards the deposit and account opening reactivation drive, as well as other future initiatives of the bank, unquote. Similarly, part of exhibit KB 7B dated 28 August 2018 also states thus, and I quote, this letter conveys management's displeasure at the poor performance of your branch, and you are hereby issued a performance warning. Consequently, this serves as a notice for you to improve the branch deposit performance. Failing with management may be constrained to review your existing relationship with the bank. Please be guided, unquote. Equally, exhibit KB 7C to G contains similar statement as in exhibit KB 7A and B. Exhibit KB 7D even stated that a review of the claimant's branch for August 2018 shows that the branch not only failed to achieve the threshold, but made a loss of 6,419,000 naira during this period. I observed from exhibit KB 7B to G that the defendant kept on repeating that, and I quote, management may be constrained to review your existing relationship with the bank, unquote. This takes me to page 63 of exhibit KB9 again, which says thus, and I quote, where a staff has received 2 consecutive performance warnings, such a staff will be exited from the bank, and this shall not qualify as redundancy, unquote. Going by the performance warning letters, exhibit KB 7A to D, and the defendant human capital policies and procedures, exhibit 9, claimant's termination on poor performance cannot be said to be incorrect, as the claimant has severally been advised and warned to improve on his performance. What more can the claimant expect from the defendant after being issued with those performance warning letters, which were for real and not for fun? From all the entire pleadings and evidence given, the claimant never protested the performance warning letters issued to him by the defendant. In fact, all the warning letters were addressed to the claimant personally. Premise on the above, I find that the termination of the claimant's employment on poor performance is not wrongful. Therefore, claimant's reliefs 5 for the declaration that the termination of his employment is wrongful fails and is accordingly dismissed. His relief 7 and 10 for compensation and damage will also have the same fate since the principal relief has failed. Claimant has also attempted to argue that he is entitled to a full month's salary in lieu of notice, but not basic salary as it is stated in Exhibit 9, because Exhibit GM1 says that he is entitled to a salary in lieu of notice upon termination. The simple answer I will say with regards to this is that since all the documents govern the parties' employment relationship, then one is specific and the other is general, and so they are not in any way in conflict with each other. It is the law that in considering situations where general and special provisions are seen to apply to a subject matter, the law takes the course which does not permit a general provision to derogate from a special provision. It follows that where a subject matter is covered by both general and special provision, the special provision apply to it in such a way that the general provision does not derogate from its effect. See the case of Dr. Umar Ardo, and Admiral Inyako. For the counterclaim, it is shown that the claimant was allocated a car by virtue of Exhibit 6, and Exhibit 9 provides that 10% of cost or the net book value of the asset of the defendant may be paid by the staff who is in custody of the asset and intends to rescind the asset. And while the existing staff cannot immediately pay, the sale price shall be computed and added to the net indebtedness of the staff or deducted from its final entitlement as applicable. In addition to this, the defendant sent exhibits KB 11 and 12 to the claimant with a schedule of payment, advising him to within 1 week settle the value of the status car in his custody or returns them if he didn't intend to return the car. However, the claimant did not respond to Exhibit 11 and or 12, but he only argued that the counterclaimant did not plead any material evidence to prove the net book value of the status car. Exhibit 9 provides that where an employee exits the employment of the defendant either by a forced exit or voluntary exit, and where the asset has not fully depreciated, the said employee should retain the asset for 10% of cost or NBV, whichever is greater. I agree with the claimant contention that the counterclaimant did not provide particulars in support of his counterclaim on how it arrived at its calculation of 2 million naira, which is the basis for the claim of the balance of 1.5 million naira. That the 10% of cost or the NBV as provided for in Exhibit 9 is dependent on the purchase price of the vehicle and its depreciation value, which are the particulars that the defendant has failed to strictly plead and prove. With this, therefore, the counterclaim fails and is accordingly dismissed. All said, claimant's case fails in its entirety, and all the relief sought, including one for cost, are hereby refused. The first issue formulated is thus resolved against the claimant. Meanwhile, the defendant's counterclaim fails too and is accordingly dismissed. The second issue formulated for termination is also resolved against the defendant in favor of the claimant.
We are most grateful to your lordship for the industry and the well-considered judgments. I pray your lordship that God will continue to guide your lordship with more wisdom to continue to dispense justice among the parties. We are most grateful, Lord. We are most grateful.
Thank you, Mr. Kelly.
Thank you, my lord.
Thank you. Are you going to appeal, Mr. Kelly? We should test it now.
I think my lord has done it a 1-1.
But you can test it now. You can.
And I think it's fine. It's one of those things.
I'm looking forward to see what the Court of Appeal is going to say about the.
I think it's okay. It's fine. It's 1-1. So no
Okay.
veto, no vanquish. So I think we'll leave it at that, my lord.
Okay.
Yes.
Thank you. Thank you so much. Thank you, Joy. Thank you.
Good afternoon, my lord.
Yes, good afternoon. Is that Okon?
Yes, my lord.
Okay, how are you?
I'm fine, my lord.
Okay. Okay. Oh, you're able to join the proceedings?
Yes, my lord. Yes, my lord.
No, any other thing.
Nothing more, my lord. We are most grateful, my lord.
Okay, so Mr. Kelly, I'm so grateful. Thank you so much. Joy.
Yes, my lord.
Okay, that's all for today. I also thank you so much.
Thank you.
And that's also any other thing I say. Good afternoon.
My lord, I'm here. Oh. My lord, I'm
Aja.
here. Now,
Aja, are you still there?
now. Yes, my lord.
So how
We
are
are
you?
here. Fine, we are all here.
Okay, what about Joel and others?
He's here.
I'm
Oh.
here, my lord.
Okay,
Yeah,
Joel,
no.
how are you?
I'm good, sir.
Maybe by
What
next
else?
week, we're going to send the file to you, Aja, by next week.
Okay, my lord.
Okay, sir. Okay,
God willing.
sir.
Yes.
Sure. Okay, sir.
Okay, so thank you so
Okay.
much. And I say
you.
good afternoon and happy
Yes.
Good
weekend
afternoon, sir. Thank you, sir.
in advance.
Thank you,
Yes,
sir.
sir.
Thank you.
Thank you, sir.
Okay, bye-bye. Okay.
Bye.
Bye.
Bye.